Hello, my name is Mohammad Babar Bhatt, student ID ISV 2207. I am here to represent the business law case, also on my behalf of my fellow student Sayyid Nadeem Jalal, having student ID WFZ 2248. Today, the case we are representing is Tame versus New South Wales. This is a case between appellant Mr. Tame and Mrs. Lavender. On the 11th January 1991, there was a motor vehicle accident occurred near the Richmond area near Windsor. The appellant Mr. Tennis and the driver of the vehicle Mr. Lavender were involved in the accident. Mr. Lavender was the one on fault because he was driving on the wrong side of the road, and at that time he had a blood alcohol reading of 0.14. Mrs. Tame, according to blood sample taken from that particular accident, yields 0.0 blood level alcohol. The traffic collision report for the incident was done by Constable Morgan of Windsor Police Station, but unfortunately the blood alcohol component of the true driver was not indicated. In 1991 February, the blood alcohol content of each driver was recorded by Senior Constable Bradley as 0.1 for both drivers. He later identified the mistake and corrected the original police statement. Mrs. Tame sued the nominal defendant, Mr. Lavender, who had been driving an uninsured vehicle. NZL handled the claim and they admitted the liability by 11 June 1991. In August 1994, the claim against nominal defendants was ultimately settled. Tame was paid some money. By 1992, the insurance company NZI was reluctant to pay physiotherapy management taken by Mrs. Tame for leg and back injury she suffered during the accident. In 1992, Mr. Waller was talking to Ms. Tame. She asked whether Tame became anxious and she talked to her lawyer, Ms. Waller, about the company refusing to continue not paying their bill for his physiotherapy. The solicitor of NZI was contacted by Mr. Waller about the matter. In 1992, when Mr. Waller was talking to Mrs. Tame, she asked whether she had consumed some alcohol before the accident. According to Mrs. Tame, she had consumed long alcohol time ago, about 20 years. She was depressed at that time. Mr. Waller said to her that NZI had a copy of that report that states that she had consumed alcohol at that time. This was due to error made by police constable Bradley, which he later corrected in the original document. This information worried Mrs. Tame, and she was wondering how many people will be told that she was drunk and she will suffer defamation. Immediately after talking to her lawyer, Mr. Waller, Mrs. Tame called the Windsor Police Station to find out whether the message in the report of NZI was true. She was told that according to blood samples were taken during the accident, her blood alcohol content was 0, and there was just an error. The administration liability was reconfirmed by the solicitor of NZI on 29th of July 1992. Mr. Waller obtained a formal apology from the police service in early 1993, and he was assured that the fault on the traffic report had been corrected. However, Ms. Tame believed that NZI were reluctant to cater for her physiotherapy due to the false result they had. So the rest of the case will be represented by my fellow student Nasir. Nasir, there you go.
All right, thank you very much. My name is Nasir Khan. My student ID is EMB3250, and I'll be representing one of my another group members. His name is Kamar Naeem, and his student ID is FCT2029. Adding more to the case, Tame versus New South Wales. Constable Morgan and the state New South Wales were sued for negligence in the district court by Mrs. Tame during the trial before Cardigan DCJ without the injury. It was found that the mistake was made by Constable Morgan, but it was mistake of acting Sergeant Beardsley. The court determined that the state was responsible for the action of Sergeant Beardsley in completing the traffic collision report. A total of 115,692 were awarded to Mrs. Tam and damage. The Court of Appeal unanimously allowed the appeal made by the state New South Wales. The appeal was conducted by Headsley J.P. Spickland, C.J. Masson, P. and the court apprehended that in absence of the actual information of particular weakness, the law only act and take care to restrain psychiatric injuries to an individual of normal fortitude. The Honours determined that it was only particularly foreseeable that psychiatric injury from cleric error that occurred here could occur for a person of normal fortitude. Adding more to the case, there were several appeals made by Mrs. Tam on several grounds. In particular, she felt that the Court of Appeal was not fair in applying more normal fortitude and sudden shock requirements. Counsel presenting Mrs. Tam submitted that none of the requirements was necessary element in her case of action and negligence for pure psychiatric injuries. Further on, it was concluded at that time that it was questionable that the duty of individual who is under investigation is owed by a police officer. Such duty proved to clash with the normal duty of police officer. Eventually, based on fixed framework and interior common law by which the significant police service is maintained and established wholly and investigate this case. Hills versus Chief is another example of West Yorkshire in 1989, AC 53. It was submitted by counsel of Mrs. Tam that she was not under analysis of the time the traffic accident was reported was completed. From the report, it was stated that Mrs. Tam was a victim of incident in respect of home where was no doubt of any criminal offence. However, it is of no order to raise the question because of the reasonable reason that followed Mrs. Tam's action failed at the outset. Other than that, the record made of the complainant's blood was wrong. The mistake once noticed was to be corrected and rectified promptly. Given the obvious nature of the error, which resulted in to both drivers being recorded the same symbol. Thank you very much.
Thanks.